Thoughts on the new court shit? I am currently searching for any high school girls from the ages of 14 to 16, because apparently that's who you need to hire to write briefs to submit to the court. Jesus. I don't think we have a chance to brief a brief. I think we got to submit our filing, and then I think they get to do their reply. And I don't know. I don't know. I don't know how far you can like stretch the fabric of like the court before they just like completely throw everything out of the whatever, because I don't know, they just keep adding so much more random crazy stuff. But I don't know. I guess we'll see. When is the ruling on the PI stuff? Well, since it's just a preliminary injunction now and not a TRO, I think that it can be anywhere from 2 weeks to 6 months. I don't know if I think it can just be whenever. So unfortunately, it'll take a while. The annoying thing is that there was a chance. I don't know how good the chance is. It's hard to estimate probability on any of it. But there's like a chance that the entire case could get tossed as a result of the PI hearing if the recommendation is to ditch the preliminary injunction, but then also if the magistrate judge agrees that there is no subject matter jurisdiction because they don't have anything that fits the statute, whatever they're alleging is not in the range of the dates or whatever. But now they've brought on more random stuff to try to make it seem like that is the case. But we don't get a chance to reply to that brief that they filed. So we just wait for the magistrate judge now, and then we just keep moving on, I think. Good times. So did they withhold that until now on purpose? That's not a real thing, I think. That's like a TV thing, like the surprise witness or the surprise or whatever. Technically, anything that they shouldn't be adding more stuff to the suit because it wasn't initially part of the pleadings, right? If you consider, like a person's due process, or if you consider the rights of people who are accused of stuff or sued, like all of the information is kind of supposed to be there in the complaint, and then you can go back and forth through your pleading stage, your discovery phase, your whatever. But it's not supposed to be like, in our last second reply, literally filed by apparently somebody having a seizure because they try to file the same paperwork like 20 times. Okay. In their last minute reply, they now have like another random affidavit from somebody and then another thing. And I don't know. I'm not sure how much detail I'm going to go into here because I don't want to reveal, I guess, my legal strategy. Like if I believe that the other side is just willing to literally make shit up. I don't know. I don't know. I'll think about it, but we'll see. When you're doing a lawsuit, do you come up with a strategy yourself, or do your lawyers come up with it? Always the lawyers. All I do is I'm willing to read a bunch. So like if the plaintiff cites cases, like I'll read it because I think a lot of the underlying material is kind of funny. Because like the cases that they cite to, all of the cases involving the statute that they're bringing in to try to sue me under, the defendants are legitimately unhinged. So like they'll cite like, oh, well, you could see that like a judge very clearly granted a preliminary injunction in this case. Diaz versus Hernandez, I think, was one of them. And if you read the alleged behavior, it's unhinged. Like the defendant there would be like a guy who's like mass sending like videos taken to like family and friends of the plaintiff because she won't respond to him because he's still trying to date her, and then he's like threatening to kill himself, and then he's like trying to send it to like college. It's like it's legitimately unhinged behavior. And I'm like, why are you citing these underlying cases? The fact pattern is not even remotely similar here. Holy shit. And neither is the evidence nor the defenses in either case too, but I don't know, it's fine. Reply in support of motion. So in a court, if you go to a court, one of the things you can ask for as part of any court case is you can ask right at the beginning, right when you file a complaint, you can say, hey, I would also like a temporary restraining order against this person. For the Trump admin, we've seen this a whole bunch in a lot of these Supreme Court cases. And a TRO is basically saying, like, I'm probably going to win the case, but if they keep acting the way they are, it's going to real bad. So please, judge, can you make it stop? So where we are in this one is they filed a TRO. It was like 2 months after the case was filed. For a variety of other reasons in the business of this filing, the judge on the case said that the TRO request was stale. It was past any point where it would have made sense to file it. And so the TROs typically roll over into a preliminary injunction. An injunction is when the court enjoins somebody from some type of behavior. You say, hey, enjoining means to stop. So you say like, hey, there's an injunction against you. You can't engage in this behavior right now. Preliminary injunction is saying, we think that the plaintiff is likely to succeed on the merits of the case. And so we're going to, while this court case happens, we're going to grant a preliminary injunction that just says during the court case, the defendant is enjoined from engaging in some type of behavior. So that's what, so now we've passed the TRO, and now they rolled the TRO into the preliminary injunction request, and then the preliminary injunction request, we're allowed to respond to that motion with what we think about it. A TRO request is typically ex parte, meaning just one party is filing it. But when you get to the preliminary injunction phase, the other party, so the defense, in this case me, is allowed to respond. So we gave our response, which is I think what I read last time. I don't know why, but I guess they're allowed to also do a response to our response. So this is their reply in support of their preliminary injunction. That's a response to our response to it. And I think this is the last one now. It just goes to a magistrate judge. And then they, whenever, hopefully at some point, they'll decide, hopefully sometime soon. I don't know what's going on the other side, but these are becoming progressively unhinged. But okay, good luck. Introduction. Introduction. This case is about defendant Stephen K. Bonnell II, or Stephen K. Bonnell, comma, seconds. Bonnell, or Destiny. Thank you. I don't know why they're using my gamer name, but I do have a real name. Non-consensual sharing of a sexually explicit video of plaintiff Jane Doe. Plaintiff or Pixie. I also don't know why they use her internet name. Instead of just referring to her as Doe, they did a protective order, which is allowed for cases like this to just be referred to as Doe. So I don't know why they continue to use her online name, but okay, whatever. Who, in the defendant's own words, was, quote, young and kind of new, end quote, at the time the video was taken. Everything I've ever told you about like legal filings or anything is just not going to apply to this. There's a lot of like extra random info here that doesn't go towards any of their case or is totally irrelevant, but they just, whoever was writing this, man, they really wanted to write. Typically, I think the court that this is filed in, I don't know if this is for all federal courts or whatever, but like the limitation is 10 pages for a response. They filed for a jumbo-sized briefing, and so they have a 20-page response that they have here. So the defendant has expressly admitted that he, one, later shared the video to a third party with a screen name Rose, two, without plaintiff's consent. This has never been admitted, by the way. And three, that he obviously, severely, at the very least, psychologically damaged plaintiff. These are the relevant facts that support plaintiff's motion for preliminary injunction. Despite being unable to dispute these admitted facts, defendant filed an opposition to the motion that is replete with completely irrelevant, deliberately inflammatory allegations that are solely intended to further harass and humiliate plaintiff. These are the facts that would be relevant maybe to winning their case, but this isn't really an argument for a preliminary injunction, even if all of this was true. Remember, for a preliminary injunction, you're trying to demonstrate that a person is still engaging in a particular behavior and that behavior is irreparably damaging my client, and therefore we need to enjoin the behavior while the court case is happening, and we need to show a likelihood of success on the merits of the case, right? So, but, hey, I guess we're just writing whatever. We just do what we want. Defendant also relies on false and misleading statements in his attempts to undermine the clear grounds which support the requested injunctive relief. The opposition audaciously strives to portray the defendant as the victim of revenge pornography. That's me. Despite the fact that, one, defendant admits he has no idea who published the video or the other videos from his seemingly vast library of intimate images. I don't know how that has anything to do with that. Okay. And 2, defendant is the sole person responsible for the non-consensual sharing of his trove of intimate images. I also don't know what that has to do with any of that, but okay. He is by no means the victim, but rather the perpetrator, and should face the consequences for his shameful and unlawful conduct. All right, off to a good start. There's a lot of speculation also, by the way, about stuff that is not really related to the complaint. Because remember, when you're in court, you're really only arguing about the issue that's brought before the court. I would imagine that it should be a little bit self-evident that I'm probably also the victim of revenge pornography, but we're not litigating that technically as part of this case because the plaintiff in this case has decided that she doesn't want to name as defendants any of the people who have actually publicly published anything, but that's her choice, so okay. To convince this court that there is no likelihood of success on the merits because it lacks subject matter jurisdiction, defendant provides a statement under oath. All statements to courts are, I believe, under oath, but that he has not shared the video with anyone other than Rose, but the evidence clearly shows otherwise. Plaintiff, we're doing the underlines here, okay? Plaintiff has obtained evidence that defendant shared the video not only with Rose, but with another woman in November of 2023, well past the effective date of the federal statute, 15 U.S.C. 6851, and thus this court indeed has subject matter jurisdiction. So one of the big issues with the case that they have is the law that they're citing to try to get this into federal court. The only cause of action that would be a federal cause of action is 15 U.S.C. 6851. But the problem is that that law went into effect after my conversations with Rose. So technically there wouldn't be any civil cause of action here. So one of the things that I said before is that they have to find like some infraction, or they have to figure out like, okay, need something. And so now we have magically another person who I guess has shown up, who was never part of the original complaint, never filed an affidavit before, wasn't even referenced in the original complaint. Now a new person has apparently shown up to sign an affidavit to join a response to a preliminary injunction request. So, okay. I'm not going to comment on the substance of this affidavit or anything unless it's public. I know that they did a motion to file some of this under seal, and I don't want to publicize anything that was filed with the court under seal, but we'll go through later. I'll see what's public and what's not, and we'll talk about it. But I don't even know if this is allowed. I don't think that you can keep having random people like trying to jump in on your thing during every motion, but okay. Additionally, as will be shown below, plaintiff has demonstrated a likelihood of success on the 3 state law claims. Plaintiff has also demonstrated irreparable harm because the video and the private messages is still accessible, verb disagreement, still accessible to the public, causing ongoing emotional distress to plaintiff. The relief requested herein is more than warranted. One of the interesting things that they try to do in this case, and I guess if we ever get to trial, although I still don't think that'll happen, but if this were to ever go to trial, it's interesting that they want to invoke all of the damages related to the publishing of the videos onto a public forum, but they won't bring any of that actual behavior into the court environment to be analyzed. Like technically, they don't want to talk about the people hosting the video, the people publishing the video online. They only want to talk about stuff related to me. So I don't know how they would ever be able to bring in any of these damages unless they were trying to claim that I published it publicly, which they're not. So it's kind of stupid, but whatever. Objections to defendant's statements of facts and exhibits. Defendant's purported statement of facts is more accurately entitled a misstatement of facts. These misleading misstatements. Wouldn't it be these misleading statements? Okay. These misleading misstatements set forth below should be stricken. I thought they were applying for TRO. Did they get rejected and now they're trying for a preliminary injunction instead? Yes. That's what's happening here, yeah. I personally was shocked when I saw this. I'm a little bit irritated that I've wasted like so much money on lawyers. I didn't know we could just file paperwork and say, can you please strike all of these things from the record? But apparently, I guess you can't Or maybe, I don't know, maybe you can. Maybe that'll be my next filing. I'll just ask for everything to be stricken from the record, please. Defendant also includes statements and exhibits that are not relevant and have no bearing on the issues before the court. It is an uncontested fact that Bonnell shared the video without plaintiff's consent. This is not an uncontested fact, by the way. This is literally the dispute that we're going to be litigating. If it goes to court, this is going to be one of the things that we fight on, but okay. If this was an undisputed fact, then it would just be a full confession and we would just be trying to settle, but all right. It is an uncontested fact that Bonnell shared the video without plaintiff's consent. The only issue contested by defendant is the date that the share occurred. Plaintiff has never alleged that the taking of the videos was non-consensual, only Bonnell's sharing of the videos. The issue of consent for the taking of the videos is not before the court. I really like how sometimes they're very big on the like, this shouldn't be before the court, and then they just want to bring up a bunch of completely random shit, but okay. Thus, these statements and exhibits are gratuitous and were included for the sole purpose of embarrassing, harassing, and prejudicing the plaintiff. Pursuant to Rules 401 and 403 of the Federal Rules of Evidence, plaintiff objects to these statements and the exhibits at docket 42.2 and 42.3, and they should be stricken. Quote, plaintiff offered to send Bonnell and in fact did send him sexually explicit videos of herself and third parties, citing Bonnell's declarations. Exhibit. This paragraph goes on to repeatedly refer to third parties. Bonnell is fully aware that the videos that plaintiff sent him were only of herself and one person, her boyfriend. He had consented to the sharing, not of multiple third parties. I like how they say these aren't matters before the court, and then they ask for them to be stricken, but then they're also replying to them at the same time. If you think none of these are before the court or should be stricken, then why are you arguing against them? Okay, I guess. All right. This is not only misleading, it is also irrelevant and prejudicial. The statement and the supporting exhibit at this docket should be stricken. In that same conversation, she encouraged Bonnell to send her similar videos of himself with third parties, same objection as above. In another message from March 19, 2020, plaintiff suggested that she and Bonnell meet in person to make sexually explicit videos together. This statement and the exhibit are not relevant to any issue before the court and are inflammatory and prejudicial. I mean, they're like a little relevant. I think they're in a basic introduction to the case and a statement of facts for like, how did we get to where we are today? I think these are fairly relevant, but okay. Bonnell is taking advantage of this forum to I like how I go also between defendant, Bonnell, and Destiny. Bonnell is taking advantage of this forum to intentionally cause plaintiff further humiliation by publishing her private sexual information. Indeed, sanctions on defendant and his counsel, and they're going after my lawyer, and his counsel are warranted. These private messages were never intended to be made public, as Bonnell is well aware. At the very least, the statement and docket 42.3 should be stricken since they serve no legitimate purpose in these proceedings. Despite claiming that at least 15 potential witnesses contacted her, purporting to have evidence that Bonnell shared the video with them, plaintiff provided only one declaration from a person named Hannah Daniels Brooke, purporting to state as much. This statement is simply false. Plaintiff has never claimed that 15 people told her that Bonnell shared the video with them. The motion and supporting exhibit states, in or around the end of January 2025, approximately 15 women reached out to plaintiff to tell her that they'd received sexually explicit images from Bonnell of other women without the other women's consent. If that's true, then why is this even included then? This has nothing to do with the complaint. It has nothing to do with Pixie. They're literally just like throwing random shit here. Then why is this even a part of it? Like, can I just add in like random, like 25 people approached me and said blah, blah, blah. Like, it's not relevant to anything, but we do like to throw random shit in, but base, okay. There are multiple other misstatements and distortions of the facts in defendant's opposition and in his declaration. These will be addressed directly in the arguments below and in plaintiff's declaration in support of this reply, Exhibit 1, here too. Argument 1. Plaintiff is entitled to injunctive relief. Plaintiff's claims have a likelihood of success on the merits. So this is what you have to show in order for a preliminary injunction to be granted. Although plaintiff only needs to show a likelihood of success on the merits of one of her 4 claims in order to prevail, plaintiff has and can show a likelihood of success on all 4 claims. Always, you're going to argue everything, of course. 1. The court has subject matter jurisdiction, and thus the Carty claim is likely to succeed. Defendant's sole argument for lack of success of the Carty claim is that he shared the video with Rose prior to the October 1st, 2022 effective date of the statute, and thus there is no subject matter jurisdiction. This argument fails outright because defendant shared the video with another woman with the screen name Abby MC in November of 2023, after the statute's effective date. See Exhibit 2 here, 2, declaration of LBMC. Thus, the court has subject matter jurisdiction, and plaintiff has demonstrated a likelihood of success on the merits of the Carty claim. So this is an important one because this would bring the alleged stuff into range of the statute. Is this declaration public? Can somebody link this? Is this like a public filing, or is this one filed under seal? Why do they keep filing stuff under a protective order? Why do they keep filing as does and then revealing information about themselves? I don't understand why people keep doing this. Okay. Their declaration: I am over the age of 18 and competent to provide testimony under oath. This is my screen name, is Abby MC. Some people might know who this is. I'll just say, yeah. I have personal knowledge of the matters herein, and if called to testify at the trial of this matter, I could competently testify as to the facts contained in the affidavit. I first connected with defendant Stephen Bunnell on Instagram in early March 2023, became a follower in Discord and other social media platforms. On September 3rd, he went to Miami, hung out, did stuff. I don't know if I should say anything about that, but whatever. Hold on. Somebody said, why would the new party affect this lawsuit? Wouldn't she be the one to have to sue you in a new lawsuit? Like if I steal some, well, because she's providing an affidavit to try to show that the original claim in this lawsuit happened within the date range. The problem is that they're trying to sue me in federal court because they're saying that an action that I did was illegal under a law that only came into effect, I think like a year or so or whatever after the alleged action. And the issue is that if that is the case, then that federal cause of action wouldn't apply. And because they cited one federal cause of action and 3 state causes of action, if the federal cause of action is dismissed because the court lacks subject matter jurisdiction, because there would be no federal claims, just the 3 state claims, then the whole case basically gets ejected. So the issue is since that one doesn't fit, and they know that it doesn't fit, they lied in their initial filing on the date that video had allegedly been transmitted. They lied about the date. I'm sure they know that they lied about the date. Now they're like basically desperately scrounging around trying to find somebody else to like, okay, well, was there a transmission video here, blah, blah, blah. And so even though this person was never a part of the original complaint, has never been referenced before or mentioned before, now like at the twilight hours, they have found somebody who is saying, oh, well, actually, I received this video on November of 2023 or whatever. On or about November 3rd, 2023, Destiny shared a Google Drive link to sexually explicit video. I recognize the plaintiff on here. I'd seen her post on Instagram. I'd seen it here. There's also a declaration about another person, about Cherry, who's also not part of this complaint or part of this case at all whatsoever. I have no idea why that's brought up here. Declarations about other Google Drive links. I recently reviewed my Discord account and realized that Destiny deleted all of his direct messages to me on the Discord platform, including the sharing of any videos of Pixie. I have retained copies of all my messages to Destiny, as well as my messages to other people about his non-consensual sharing of sexually explicit videos. I do not want to have my identity publicly revealed, since I have recently discovered that he also shared sexually explicit videos of himself and me with other people without my consent, just like he did Pixie in the other one. So a lot of stuff here that's not the subject matter of the complaint, that has nothing to do with any of this case. So I don't even know if we end up responding to any of this, because it's, whatever. But so this is their twilight hours person that they brought in for this. Ideally, there would be some kind of evidence of any of the claims here. I don't know what I'll say until they rule on this preliminary injunction, but let me just say that there's absolutely no evidence of any of this. But who knows? I could be lying, or I could be crazy. So this is a declaration of a person. We don't know who this is, though. It's just Abby MC, thankfully. They filed as a Jane Doe under protective order. Is there any actual evidence that you shared it after that date, or is it just her saying that there is? It's just her statement. That's it. Thus, the court has subject matter jurisdiction, and plaintiff has demonstrated a likelihood of success on the merits of her Carty claim. So we're live again. Okay. So we're back. Okay. So we are back. Assuming what that affidavit, I think is what you call somebody who fills an affidavit, is true. Wait. Is that all they need to rule on this? No, even if that were true, that wouldn't necessarily guarantee a preliminary injunction granting or any or win on the case, whatever, but okay. Where are we at? Okay. Defendant has not, or plaintiff has established a likelihood of success on her state law claims. The defendant has not and cannot demonstrate that plaintiff does not have a likelihood of success on the merits of the 3 state law claims. These claims will be addressed seriatim. I actually don't know what this word means. Hold on. Oh, no. One after another. There you go. Aren't you doing a lot to reveal her now? I'm not revealing anybody. I'm just reading the filings. They're all public. Count 2, sexual cyber harassment. Defendant blithely contends that plaintiff has not shown the requisite intent to harm the plaintiff, purportedly because he belatedly hired an attorney after being put on notice of plaintiff's claims and made some attempts to remove the video from the numerous websites. So the problem with this sexual cyber harassment claim, and why I think if the federal count gets dismissed, I seriously doubt they would refile in a state court. I mean, they could theoretically refile, but the issue with your sexual cyber harassment claim is that this is this requires like really unhinged behavior. Hold on. Is it not going to load? Okay, fuck. I think that this one, there's 2 elements that I think my case very clearly doesn't meet. But the 2 elements that are very clearly not there, I would say, one is it has to be like an intent to inflict severe emotional distress. Like you're intentionally trying to, like a revenge porn thing, basically. Like I'm trying to this person. And I think the second thing is I think it requires a public publishing of the information. I've noticed that a lot of penny lawyers on YouTube or whatever or like people in forums try to make this weird argument of like, well, technically, if you post anything on any message ever, or if you send a link to somebody, technically that counts as publishing to the public, and that's just not true. There is no court case you can cite where that is the case. It's just not the case. Typically, this requires publication on a widespread website that people are accessing or can view. But yeah. Wait, 784049. So this is to qualify for this sexual cyber harassment thing. You have the legislature finds that a person depicted in a sexually explicit image taken with the person's consent may retain a reasonable expectation that the image will remain private despite sharing the image with another person, such as an intimate partner. It's become an increasingly common practice for persons to publish a sexually explicit image of another to internet websites or to disseminate such an image through electronic means without the depicted person's consent, contrary to the depicted person's reasonable expectations of privacy, for no legitimate purpose, with the intent of causing substantial emotional distress to the depicted person. When such images are published on internet websites, the images are able to be viewed indefinitely by persons worldwide and are able to be easily reproduced and shared. Yeah, so there are people that probably could qualify for this, but unfortunately, for whatever reason, plaintiff has decided not to name any of those people or any of those parties in the lawsuit, so okay. So this is the sexual cyber harassment statute. But, okay, so they said, defendant blithely contends that plaintiff has not shown the requisite intent to harm the plaintiff, purportedly because he belatedly hired an attorney after being put on notice of plaintiff's claims and made some attempts to remove the video from the numerous websites. But defendant also claims he is the victim here, since not only the video, but multiple videos and sexual content of his was published online. Clearly, he hired an attorney to remove his own content because it was harming his career as a streamer. Regardless of defendant's claims, the undisputed facts are that he intentionally and non-consensually shared the video with at least 2, and most likely many more, women, knowing full well that plaintiff would be and was severely harmed by such disclosures. Again, if you want to talk about the videos being published on websites, it's weird that I don't know how you can say anybody was severely harmed by such disclosures when all of the harm came from the public publishing of the videos, which I am not even being alleged of having done, but okay. Furthermore, it was readily foreseeable by the defendant that his unauthorized sharing of the video could lead to its further dissemination to others. I think that this is very funny. I like this argument. I think it's a little bit comical because foreseeability is one of the things that you argue when you're talking about proximate harm or when you're talking about harm in a particular case. And the argument that they're essentially running with here is if you send a video of sexually explicit behavior to somebody, obviously that video is going to go public. I think it's pretty obvious why this argument is incredibly stupid in this case. But okay, whatever, I guess. Count 3, intentional infliction of emotional distress. Defendant's only argument to this claim is that the single private transmission of a video to one individual does not rise to the level of extreme conduct. But it was clearly not just one transmission. Clearly, because of the twilight hour affidavit they brought in, okay, in the response to the response for the preliminary injunction request, who was never part of the original complaint or any amended complaint or has filed anything yet, but okay. It was clearly not just one transmission. See Exhibit 2, this declaration. The evidence at this early stage of the proceedings, before discovery has even commenced, I don't know why they're saying this. We're already in the discovery phase. They've already made requests to sites. They can make requests from us. They still have yet to do so, but okay. Before discoveries even commenced, shows that Bonnell intentionally and recklessly shared the video with at least 2 women. Defendant's claim that he only shared the video once with Rose has no credibility, not only because he shared it with Abby MC, okay, but also because he made the same claim to another individual. Witness B's sexually explicit video with defendant was also leaked in the November 29th, 2024 leak of plaintiff's video. After the leak, defendant also told Witness B that he had only shared her video with Rose, but shortly thereafter, multiple women informed Witness B the defendant had shared her videos with them. See Exhibit 5 here too. Declaration, do we have Exhibit 5? Link it. Stop stuffing your fat fucking mouth. I will. I have a good ass cookie here. Okay. Is this Witness B? See Exhibit 5. Oh, I thought they referred to somebody else as Witness B. But this person says that I met April 2022, reached out to the defendant, blah, blah, blah. We remained in contact, became friendly with his wife, made sexy videos for him, myself, and his wife. Told him I didn't consent to these videos, to sharing these videos with me. Together we began sharing videos and pictures of sexual relations with one another. Blah, blah, blah. Invited me here, made stuff, him and his wife. In late November 2024, I was harassed by multiple individuals while on Discord who informed me that a video involving Destiny and myself had leaked online. After confirming this was the case, I confronted Destiny, who told me that he was sorry that any videos involving myself had leaked because of him. As he also told me he only shared this content with a single individual who went by the screen name Rose. This person says these things. They don't attach any evidence of any of these claims, but we have an affidavit, I guess, which are good as gold. I don't know. I guess it doesn't matter because it's already filed. One thing that I think is very funny about this, I'm not going to talk in depth about any of this, but they say, sometime after the November 29, 2024 leaks, I discovered that Destiny had deleted messages between himself and I related to the foregoing. I still have messages with this person. They actually deleted all of their messages with me, but okay, that's a claim, I guess, that you can make. I have, but whatever. Anyway, again, we have an affidavit. Unfortunately, no screenshots or evidence attached to any of it, but listen, okay? They're just affidavits, okay? We do a little bit of writing. After the leak, defendant told Witness B that he'd only shared her video with Rose, but shortly thereafter, multiple women informed Witness B the defendant had shared her videos with them. Also, again, this person is not part of the complaint, so I don't know why any of that is relevant to any of this. But this like, we're not here to litigate any of these issues, or at least not yet. So I don't know, whatever. But okay. Moreover, the intentional infliction of emotional distress claim is not just about Bunnell's reckless sharing of plaintiff's intimate images, but adding insult to injury. It is also about his subsequent publication of her private messages and his subsequent and ongoing harassment, belittlement, and bullying of plaintiff on his public forums. Here again, defendant relies on his false statement, so disclosure of private facts, that he only shared the video with one person in an attempt to undermine plaintiff's likelihood of success on this claim. But the evidence shows that not only did he share it with at least 2 women, but that when he shared it with Abby MC, he shared it on Discord via a live Google Drive link. In fact, defendant has admitted that he uploaded his trove of intimate images onto Google Drive links and then would share a link to the drive to his random followers. The Discord user with the screen name SoloTinyLeaks, who published the video and other videos. Oh, this person is invoked. Interesting that they don't show up anywhere on the complaint in terms of being like named as a defendant, but interesting. Stated that he obtained the videos from Bonnell's Google Drive link. Moreover, there is evidence from another individual that Destiny shared with her sexually explicit videos of him with other women via Google Drive link. This is just all like... None of these issues are, it's just funny because none of these were before the court. None of these have been litigated. None of these have been like, they don't really attach any evidence. It's just more affidavits of people saying like, this happened, but like, okay. Thus, because Destiny used Google Drive links to share his pornographic content on Discord, those links remain live and accessible to anyone with a Discord account. In this case, the links remained live for years, which is why SoloTinyLeaks was able to access them, and which is the reason that the video and other content was substantially certain to have become one of public knowledge, which alone defeats defendant's assertions regarding the merits of this claim. So again, I will say that these arguments are very funny. I'm pretty sure that these came from Kiwi Farms because I saw them floating the idea like, oh my God, somebody should bring this up. However, the reason why these are funny arguments is because it could be the case, for instance, that same Google Drive link is what was initially shared with the plaintiff in this case. And if they're saying that it is a certainty that a Google Drive link is basically publicly accessible, then that would mean that the individual consented to the publication of it the entire time because she literally had the link the entire time. So this is the second argument they've put in here that, if followed to its logical conclusion, actually completely self-destructs this entire complaint. But hey, you know, I'm not here to judge. I'm just here to watch, okay? Also, technically, if you really want to get technical, this is one of those like Reddit tier arguments that doesn't really work on its face because it's trying to abuse some weird technical loophole. I think that the argument they're trying to run with here is like, okay, even if it was shared prior to the date of the statute, it's still hosted live after the date, right? So then it should count. Well, if that's the argument you want to go with, then arguably every single video shared anywhere is technically live with a certain link after it. Because if, like, for instance, if you share any video on Discord, for instance, it's actually shared in the form of a link. You can right click it, copy that link, send it to anybody else. Technically it's hosted, right? So, so this is like it's kind of a meme argument. Maybe it wouldn't be a meme argument if they actually ever cited underlying cases to support any of their claims, but none of the cases that they cite ever actually support any of the things that they say. But you know, it is what it is. Plaintiff has established irreparable harm requiring injunctive relief. Defendant contends that the harm to plaintiff has already been done, and there is no ongoing or further imminent irreparable harm to plaintiff. This contention is directly contradicted by the fact that the video is still accessible to the public on multiple websites, causing ongoing harm to plaintiff. Again, I am not the publisher of those, nor am I the hoster of those, nor have you named them as defendants in this lawsuit. So I don't know why they're trying to invoke any damages done by those things. I have no, unless they were claiming that I also own those websites. But okay, I don't understand. Defendant's empty and self-serving assertion in his declaration that he made efforts to try and remove the video is not supported by an iota of evidence, despite submitting over 12 supporting exhibits. Nor did defendant's counsel, Mr. Bretler's declaration, make any assertions or provide any evidence of any efforts made to remove the video. I love that she's like shitting on my lawyer too. Also, can I just say, holy my law firm is super expensive, which is why tune into kick.com/destiny. If you watch me there, if you want to support, okay, brave streamers, small scale streamers trying to make it in this world, okay? I feel a great deal of pride reading my law firm's filings and the professionalism that they exhibit, the research that they do, the writing that they do. I very much appreciate it. Holy shit, Jesus. Defendant has the temerity to suggest that the onus should be on plaintiff to have the video removed, falsely stating that he is not aware of any efforts that plaintiff made to have the video removed from any site, including Kiwi Farms. First, This is yet another of Bonnell's knowingly false statements. On December 5th, 2024, plaintiff exchanged direct messages with Bonnell, asking him for his help in removing the video and informing him of her efforts and the steps she was taking. Exhibit 1, Declaration of Jane Doe. I looked through her logs. I don't think I do remember. I think she was asking me how to like report stuff, but I don't know if any of that ever got taken down. I don't know if they made any requests to like Kiwi Farms or anything, but okay. The onus for such action should be squarely on the perpetrator, not the victim. Moreover, plaintiff hired the undersigned counsel in January of 2025 to attempt to get the video removed from Kiwi Farms and the multiple other sites at her own expense, and significant efforts were undertaken. See Declaration of Joan Schlump Peters. Exhibit 3. Link me Exhibit 3. Declaration. I, Joan Schlump Peters, declare as follows. I am an attorney admitted to practice pro hac vice in the above captioned area. That just means that she's allowed to practice for this case here. Not practice, I'm sorry. She's allowed to represent the plaintiff here because her jurisdiction that I think that she's authorized to practice law in is Puerto Rico, but they file this so that you can bring in a lawyer. I have personal knowledge of the matters contained herein, and if called upon to testify, I could offer competent testimony thereto. I'm submitting the statement to support a plaintiff's motion for preliminary injunction at docket 21. I don't know how common it is that like your lawyers are like are also filing, you know, like statements or affidavits or whatever. But I don't know. It's fine. Okay. Regarding defendant's claims that he's been preserving evidence, Mr. Bretler asserts in his declaration that during a telephonic meet and confer with plaintiff's counsel on April 9, 2025, I informed counsel of the steps defendant has taken to preserve evidence in connection with this case. This portrayal of our meet and confer is not accurate. During the meet and confer, Mr. Bretler asserted that his client was not destroying evidence. It was only after being pressed repeatedly for specifics as to how his client was preserving evidence that Mr. Bretler finally responded that his client was preserving evidence in JSON files. No other specifics were provided. Notably, I love that it's like a lawyer versus lawyer battle. Is she going to be shitting on? Okay. Notably, Mr. Bretler's declaration to the court does not provide any specifics as to the steps defendant has taken to preserve evidence and does not mention JSON files. Defendant Bonnell's declaration, however, claims that he has preserved evidence by exporting all relevant Discord messages into an HTML file. Defendant's statement makes no mention of preserving evidence in JSON files. These are two completely different methods of preserving evidence with very different results. None of this is true, but she can. All of the tech shit. I actually got so triggered reading all of this last night. Oh my god! But on behalf of the plaintiff, I and my co-counsel have made significant efforts to try to remove the video from the multiple platforms, including Kiwi Farms. I checked all the videos, and basically all of them are still up, except for one. So it seems like they didn't do shit either. I guess you would say there's not one iota of evidence to suggest that they did, quoting their own language. But we have retained experts to assist us in this time-consuming and expensive process. What, filing DMCA claims or takedowns? Okay. Although we succeeded in removing the video from several of the pornography websites, we have not succeeded in having it removed from Kiwi Farms or other sites where it is still visible. These sites are resistant to removing content and often will only do so pursuant to a court order. Oh, hey, that makes it sound like I wasn't able to get it taken down. Good one. On behalf of the plaintiff, I and my co-counsel have also expended significant resources in having subpoenas drafted and served on multiple social media sites in an effort to preserve evidence and then have it deleted from the sites. I don't know if subpoenas are made public. Jen, am I allowed to talk about it? Bro, I will just say the subpoenas that they're trying to write for some of these platforms are some of the most disgusting subpoenas I've ever seen written in my entire life. Holy shit. Actual disgusting cancer AIDS. I don't know if any of the discovery stuff, I don't know where Jen is at, or Leon Law. I don't know if you're allowed to, I don't know if those are supposed to be like private matters or not, like who they're trying to subpoena or not, but okay, well, if lawyer people come out, you can tell me. To date, we have served subpoenas on Discord, Google, Instagram, and Kiwi Farms. Defendant is fully aware of these subpoenas since his counsel was provided with prior notice and copies of the subpoenas. Pursuant to this, I declare penalty of perjury under the laws of the United States, best of my knowledge, blah, blah, blah. Okay, that's her declaration. They didn't really mention what significant efforts were undertaken, but I guess they just said that significant efforts were undertaken. So, all right, based. Moreover, in addition to the video, the private messages published by defendant are still accessible to the public on social media sites under his own control and cause ongoing harm to plaintiff. Oh, so some things are under my control and some things aren't? How am I supposed to get things removed from things not under my control? Okay, good one. Since learning of the non-consensual sharing of the video, plaintiff has suffered extreme emotional distress and continues to suffer precisely because the video and the private messages are still available for the public to view. Additionally, plaintiff has demonstrated an imminent risk of further non-consensual disclosures of intimate images of herself, as well as further publication of her private sexual information by Bonnell. See Brooks' declaration on the docket 21-2. Bonnell offered to share the video even after the November 29th, 2024 publications. I think we've put this in like 2 or 3 filings by now, but they were just lying. They just like to lie. Any videos that I was referencing, 1, nothing was transmitted, but 2, any videos that I were talking about with this Hannah Brooks person were videos of me giving oral sex to a female. I think that's what eating means. They're not the video that is the subject of this complaint. They've provided no evidence of that. They continue to repeat this claim, even though it's like patently false if you just read Hannah Brooks' declaration. But they just like to lie over and over again, I guess. So based, I guess. See also plaintiff's declaration, blah, 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 blah. Post disparaging plaintiff. This behavior tends to show the defendant post. Every single court case that they cite here is so fucking funny. So, quote, this behavior tends to show the defendant poses an imminent risk of dissemination of plaintiff's intimate visual depictions. Doe v. Constant. This case, I bought a Pacer account because I'm curious. So I was reading through the preliminary injunction that was granted in this case. In this case, Doe v. Constant, the guy was literally mass sending videos to the defendants or to the plaintiff's family members and coworkers and trying to DM her. I think he wanted to date her still and was like threatening to kill himself, and then was threatening to continue to send videos and shit that he'd taken. I think some of these taken like without her even knowing to like all of her friends and family. And so the plaintiff claimed this. So they're like, hey, we want like a preliminary injunction. And then the defendant said, actually, I didn't do any of this. And then the plaintiff hired a private investigator to figure out what was going on. And the 2 emails that were sending these videos to friends and family, both of them belonged to the defendant. So he was like making AKAs and then mass sending these videos to friends and family. I was like, holy shit. Every underlying case that they cite here is just so funny how crazy the fact pattern is versus the fact pattern in my case, allegedly. But, well, no, a fact pattern, a fact pattern you're alleging, but. Oh, wait, actually. I think I downloaded this when I read it. Defendant Douglas Constant. Yeah, wait, hold on. Plaintiff alleges that defendant Douglas Constant Jr., defendant, surreptitiously acquired nude photographs of plaintiff and distributed them on multiple occasions to her family, friends, colleagues, and her office landlord. She alleges that defendant has additionally threatened to send these photographs to various regulatory bodies that govern her profession. She alleges that defendant demands plaintiff to admit to the relationship with defendant to her family, or he will disclose the photographs. And then he continues to contact her even after her attorney sent defendant a cease and desist notice. She further alleges the defendant has threatened suicide when faced with plaintiff's non-response. Plaintiff employed an investigative firm that purportedly linked the various IP addresses, email addresses, phone numbers, and online accounts utilized in these events back to defendant. Accordingly, plaintiff brings claims for unauthorized disclosure of intimate images under the Violence Against Women's Reauthorization Act and state tort claims. I will say, my God, reading the filings for these, not only are the defendants unhinged, but these people are also, I can tell, like, oh, these people know how to do real filings and like sound like real lawyer people. These filings are just crazy. I don't know if like they're just like they're letting the plaintiff write these herself as like practice or something, but like holy fuck. So at the hearing for this preliminary injunction, at the hearing, plaintiff's counsel elicited testimony from plaintiff and her private investigator, Dan Halpin. Plaintiff's counsel also produced the communications containing the intimate visual depictions of plaintiff and the investigator's written report. The defendant chose to only cross-examine the plaintiff. I guess he just wanted to talk to her. And the defendant did not produce any rebuttal evidence. But Yeah, I don't know. The underlying cases they cite are always fucking insane. But okay. Furthermore, as fully set forth in plaintiff's motion, an ongoing violation of the right to privacy presumptively constitutes an irreparable injury. This is true. And Cardi specifically provides that victims are entitled to preliminary injunctions. It's also true. Defendant failed to even provide or to even respond to these arguments in his opposition, presumably because the holdings are incontrovertible. I don't even know what that means. I'm not going to argue against I'm not going to argue against what the statute says. Like, yeah, the statute explicitly says some of the relief that can be offered to a plaintiff can come in the form of a temporary restraining order, a preliminary injunction, or an injunction on the behavior, I think. Why would I argue against why am I here to argue against the statute? What? The court may, in addition to any other relief available at law, order equitable relief, including a temporary restraining order, preliminary injunction, or permanent injunction ordering the defendant to cease display or disclosure of the visual display. Yeah, I'm not going to argue against that, obviously, but okay. Yeah, I don't know what they were looking for here. It's like for us to try to take something to the Supreme Court. What is CARDI? I don't remember what it stands for, but it has to do with like an unauthorized disclosure of intimate images or something. It's something in that, but it's basically citing it's the law that we're talking about, basically. Instead of responding, defendant asserts that plaintiff provides no evidence that Bonnell shared the video on more than one occasion. He has not. No evidence that Bonnell intends to share the video. Again, he does not. And no evidence that Bonnell has been or will do anything to exacerbate harm to plaintiff. Each of these assertions is false. 1. The declaration of Abby MC proves that Bonnell has shared it with at least one other person. Our Twilight witness here. The declaration of Brooks proves Bonnell is still offering to share the video. This is not, unless my literally eating somebody. This is not true, but okay. And 3, Bonnell continues to speak disparagingly about plaintiff and her pursuit of justice on his platforms on a regular basis, thus continuing to harm her and driving traffic to the site where the video is posted. I'm allowed to talk about public filings. I don't know if they're trying to sue me because I'm not allowed to talk about public filings, but I am relating to this. I'm absolutely allowed to speak about these. You're literally filing these in public court. Like, welcome to court, I guess, but okay. In short, the fact that the video and the private messages are still accessible to the public is sufficient to constitute irreparable harm, warranting injunctive relief. I agree with this to some extent. But this injunctive relief should probably be against the people who are still making those videos accessible to the public. But hey, what do I know? In a case that is directly on point, involving the non-consensual disclosure of intimate images, the court found irreparable harm warranting affirmative injunctive relief precisely because the sexually explicit, quote, video remains visible to the public, end quote. Diaz versus Hernandez. This case is directly on point. Oh, I looked this one up. I don't have. I think this might be the 6x9 case. In this one, I think the defendant himself was literally still hosting all of this publicly. This is also another unhinged case. If anybody wants to link me the docket on this, we could read the preliminary injunction that was granted here. But the defendant in this is fucking crazy. Jesus, but. Similarly here, without a preliminary injunction from this court, this irreparable harm to plaintiff will continue. Again, it's funny because like the harm that is allegedly happening to the plaintiff, I have absolutely no ability to do anything about that, short of a DeLorean that can go 88 miles per hour. There's nothing, like, I don't know what, yeah, but okay. 1, the harm to plaintiff is not self-inflicted. In a shameful attempt to minimize his own responsibility for his unlawful conduct, the defendant now has the audacity to claim the harm experienced by plaintiff is self-inflicted. This claim is based on a fabrication of the facts. Bonnell falsely claims that, but for plaintiff's own public comments about the leak, she would have, for the most part, remained anonymous. Although it is not clear what defendant means by remaining anonymous, quote, for the most part, end quote, The fact is that well before plaintiff published her Substack on January 20th, 2025, the streaming world was fully aware that Pixie was the woman in the video. First, her face and hair are easily recognizable. See declaration of this person. Second, shortly after the video was published on November 29th, 2024, and well before Pixie posted her Substack, she began receiving hundreds of harassing messages related to the video. Again, video was published by who? The behavior that is being spoken about here, that all of the proximate and foreseeable harm was coming from, the publisher is not ever listed in this complaint. I don't know why we're talking about any damages that are resulting from this when we're not, the publisher of this is not named in the complaint. So I don't know, but okay, we'll see, I guess. Individuals were constantly making hateful comments on her posts, all based on their knowledge that she was the woman in the video. Comments such as, "You got exposed, LeMayo, I have it downloaded," "Destiny Guzzler," among other lewd, nasty, and demeaning remarks. Is this exhibit public or is this exhibit private? I don't know if this one was filed under seal or not. It's on the docket. I think it can still be on the docket, but filed under seal though, right? Wait, fuck, what? Oh, stone, steel. Would it be fair to say that the only reason they try to paint you as the publisher is because you are the only person they could get any money out of? That would be a very aggressive thing to state about plaintiff. And very mean. Okay, let's get a sample of these horrible comments. Hi, I've been going through a tough time. If I haven't responded to your DMs, it's because I'm overwhelmed, nothing more. Is it because your sex tape got leaked? That's quite the L. Damn. 14 likes. Whew, that's a big one. One of the funny things is, I think I put this in the little mini festo that I wrote online, and I think also me and another person even agreed that it felt like some of the things that plaintiff was publicly tweeting, it felt like they were almost trying to bait some type of negative engagement. And now I feel like that actually might have been the case, because it seems like I think that this original tweet was deleted. So they must have taken a screenshot and everything and backed all of this up and then deleted their original tweet. So they tweeted this on the same day, by the way, that they began making threats of suicide to me in order to get me to settle before any court stuff. It seems like she made that statement, waited for a big account to respond, and she finally got it here, and then she screenshotted it and then deleted her tweet. But hey, based, okay? And then we have a handful of comments that were not good, that were written on the, I think this is her YouTube channel. Based evidence, not based. You shouldn't be harassing people. And then we have Annie Loof, who is some unhinged person who is in a Justical Discord server person. So based. Good job. What happened to the Z call? I had a misunderstanding with her, and I thought that we were talking publicly, but she wants us to speak privately first, just to make sure everything is, or that we just to talk first, feel comfortable. Sizable content creators that had tens of thousands to hundreds of thousands of followers were also making public comments stating that it was Pixie in the video with Destiny. Finally, Pixie felt that she had no choice but to go public and defend herself when 2 defamatory videos were posted, including her private messages claiming that she took hush money and that she didn't care about the victims. This statement is also a lie. If you watch any of those two videos, inside of the videos, you can see that in one of Pixie's DMs to Straighteraid, she literally has her entire public Substack post outlined, and she sends her a sample of it first. I think this is about a week and a half before any other videos are published, showing that she was clearly always planning on going public with this, and she was getting ready to post it, basically. But, hey, we do a little bit of creative writing, I guess. These videos were rapidly gaining tens of thousands of views. In an attempt to protect herself from further damage to her reputation, Pixie was left with no choice but to post her Substack so that she could tell the truth. Pixie also had no choice but to start a fundraising campaign in order to finance this suit against the defendant, who has substantial financial resources at his disposal. Bonnell also makes baseless claims that plaintiff promoted the video. There is no evidence to support that statement. In fact, the evidence the defendant has submitted supports the exact opposite conclusion. The video's popularity from the day it was uploaded was due to the immediate identification of both Pixie and Destiny. In fact, on November 30th, after the initial posting on Kiwi Farms, the website crashed repeatedly as a result of the large number of viewers. This one actually did trigger the of me because the exhibit they attach, including a screenshot of the November 30th, 2024 post by the Kiwi Farms administrator. The surge of traffic to the Kiwi Farms related to Destiny's blowjob video has caused a fatal database error, and I will need to do a rollback to a recent backup. This is about the video of me giving a blowjob, not anything else. The fact that she would try to subsume this as part of her lawsuit is actually beyond reproachable, is actually disgusting to me. But you know what, Queen? You go off. Yes, Queen, all right? Based, actually. This was around 2 months prior to plaintiff announcing her lawsuit. There is no evidence indicating the website crashed after she posted her Substack or anything of the sort. Thus, defendant's knowingly false assertion that it was not until plaintiff published her Substack that she was identified or that she promoted it is directly contradicted by the evidence. So I don't think I even made that claim that she hadn't been identified at all. I just thought it was wild that she literally gave search terms in multiple websites where it was uploaded, so anybody can literally just type it in, especially when almost none of those videos are even of her. But hey, Yes, Queen. It shocks the conscience the defendant, who intentionally and repeatedly disseminated a sexually explicit video of plaintiff without her consent. And as a result, this video was published for untold thousands of people to see, causing the plaintiff severe emotional harm. With the video still publicly available, could have the temerity to claim that her harm, I don't know why we use this word twice in the same filing, nice, was largely self-inflicted because she tried to defend herself. Not only is injunctive relief fully warranted, punitive damages will be necessary to punish this defendant for his outrageous conduct. The requested relief is necessary and warranted. Defendant's gaslighting and distortion of the facts continues. Plaintiff's motion requested an order enjoining defendant Bonnell from sharing, publishing, or transmitting, whether directly or indirectly, the videos and or private messages. I don't know what it means to indirectly do that, but okay. Compelling him to remove all publications of plaintiff's private messages and private information from all forms of public media he controls, either directly or indirectly. Motion upon Bonnell completely distorts and rephrases the second request as ordering him to remove the video and all messages between him and plaintiff from all forms of public media. Bonnell's inclusion of quotation marks is particularly disturbing and misleading. The second request unambiguously and specifically requests only that Bonnell remove the private messages from social media under his control. Yet notice how they keep calling out or like more and more about all of the harm resulting from the public publication of stuff, but okay. The majority of Bonnell's argument is based on his distortion of the requests and thus should be stricken or disregarded by the court. Strike it from the record, Judge. I do not agree. Okay? I do not agree. Strike that. I feel like this is the, wait. Bonnell contends that the requested order is not necessary because the conduct is no longer occurring. In support of this argument, Bonnell falsely alleges that he has not shared or otherwise transmitted the video to any other third party. Since April 2022, this claim lacks credibility given that in November 2023, Bonnell shared the video, and in January 2025, he again offered to share the video. So the second thing is a lie. This first thing they've provided literally no evidence of, but okay. Bunnell also falsely told witness B that he only shared her videos once with Rose, but witness B then found out he shared them with multiple women. There's also no evidence of this as well. Also, I don't even know why any statements like this from witness B would even be here, because this is not an issue before this court at all. It literally has nothing to do with this. This hasn't been litigated. This isn't, but okay, I guess. Moreover, if, as Bunnell claims, the conduct is no longer occurring, and he has no intention of sharing the video in the future, then, logically, Bunnell should have no objection to the requested relief. This is my favorite argument. If I want to file a preliminary injunction against you for a handful of behavior that you say you're not engaged in, you should just like automatically accept it, right? Because if you're not doing it, it shouldn't matter. I should be able to just, enjoin any behavior I want. As long as you're not doing it, it should be fine, right? But okay. Requested order should be granted. Once again, defendant completely distorts the request, and thus the majority of this argument should be stricken or disregarded by the court. Plaintiff did not request an order of spoliation. Wait, is it spoliation? I thought it was spoliation. Maybe it's spoliation. Oh, it is spoliation. I kept saying spoliation. Why is nobody correcting me on this, you fucking retards? Plaintiff did not request an order of spoliation. So, okay, so there's either a misspelling or they don't know the correct term, but that's fine. Or maybe in Florida we say that, I guess. Rather, plaintiff requested the court order defendant to cease and desist from destroying evidence and compelling defendant to retrieve all messages that he deleted and preserve all discoverable evidence that is in any way related to this case or that could prove any non-consensual disclosures from his phones, computers, tablets, online accounts and platforms, or any other devices, and preserve all internet routers or other hardware in their current form or image so they may be searched for information relevant to this action or be at risk of an order of spoliation. Destiny, get the TRO orders they are seeking. It actually doesn't even make sense. Order 2, asking them to enjoin you, doesn't mention in your control. And Order 3, asking you to remove all private info, says directly or indirectly, LOL. Yeah, I know. It's just, this is all like meme shit, but I don't know. I don't know, man. The request was made for the very purpose of ensuring that evidence would not be destroyed so that plaintiff could avoid having to make a motion regarding spoliation. What does this mean? I'm sending you a request to preserve evidence, and it's like, okay, got it. Hold on, I'm also going to enjoin you from destroying evidence. Why would you stop me from doing it? You already sent me a request to preserve. I already have a legal obligation to preserve evidence. Why would you also like try to enjoin me from destroying it? Because you're not supposed to destroy it. It's like, okay, I'm already not supposed to. Like, why not file an injunction against every single illegal behavior ever? Like, if I'm not doing it, it shouldn't matter, right? I want to enjoin the defendant from sexually assaulting anybody, assaulting anybody, breaking any contracts, extorting anybody, stealing, committing bribery, criminal conspiracy to, like, why not just enjoin me from every single illegal behavior ever? Like, what? Okay, I guess. All right. Defendant should have no objection to this request because he's required by law to preserve evidence. What? Yes, I'm already required. So why do you need a preliminary injunction for it? The law already requires us. The reason the request was made is clear from the evidence presented in the motion. Multiple individuals informed plaintiff that Bunnell deleted all of the messages he sent to them, including the sexually explicit videos he sent. What does that have to do with the case before the court? Number one. Number two, this speaks nothing to whether or not the evidence was preserved. Number three, there aren't even dates referenced here. These messages could have been deleted a long time ago. Number four, plaintiff hasn't even requested from defense anything for discovery. They haven't even made a request for any information, so you don't even know if I have anything backed up or not. Number five, I would argue, I've already demonstrated to both this court and to plaintiff that I have backed stuff up because I can prove that they have already engaged in spoliation, actually, by deleting messages that they haven't responded to, by the way. They haven't given a response to that because plaintiff, in this case, has deleted and retroactively altered messages right before they launched a public filing. They did that, and I have evidence of that. And the only reason I have evidence of that is because I did make archives of this, and they haven't responded to that they actually have engaged in that behavior at all. But regardless. And Bunnell also deleted his messages with plaintiff. Based on this pattern of evidence being deleted, a request for an order to preserve is only logical and indeed necessary to prevent the risk of further spoliation. Let's say that it was the case that I was deleting evidence. Why would an injunction even stop me? If I've already been put on notice, I already know that you're not supposed to delete evidence, so why would you try to enjoin me from deleting evidence if you already accused me of deleting evidence when I already know I'm not supposed to delete evidence? You've already asked me to delete it. Wait. But, okay, based. Defendant's own exhibits to his opposition show evidence of his spoliation. The defendant provides 2 screenshots of the same message thread, one containing the link to the video, the other without the link, as a result of the defendant deleting the message, directly evidencing that he has been deleting evidence of that nature. You understand how if I make a backup of messages before they're deleted so that I can demonstrate that other people have deleted messages and they're going, gotcha. What do you mean you got me? You deleted evidence. How do you know I deleted evidence? I know you deleted evidence because you preserved the evidence and you can compare the preserved evidence you have with the deleted evidence and show that you did delete evidence. How can I prove my own spoliation? By definition, that doesn't even make sense. You're going to prove that I deleted evidence by citing the evidence that I preserved? Like what? This whole thing is so fucking wacky, but okay. Anyway, continuing on. Defendant claims in his declaration that he has preserved evidence, but only asserts, without elaboration, that he used the Discord log exporter for messages on Discord. No mention is made of preserving evidence on other social media platforms. Moreover, Discord log exporter is a third-party app, not verified or approved by Discord. It does not save relevant metadata from the messages. That's not true. Nor can the authenticity of the message be verified using the log exporter. While that's true, you can't really verify the authenticity of any message ever, right? Like, you can always doctor any screenshot. I could theoretically edit the HTML I've exported. But you can doctor anything. I mean, unless Discord is literally going to provide you themselves, with the data, like how do you even prove this? But okay. Also, I don't know how they would know whether I've backed anything else up on any other apps because they haven't requested anything from me at all, but okay. All right. It converts messages into HTML files, but there is no way to verify if the defendant has truly archived or exported all of his messages or selectively left out certain ranges in an effort to conceal data. Any evidence he may have preserved is still subject to tampering. All evidence is. And the defendant could have deleted certain messages and then archived the chats. Oh, you mean like plaintiff has and still hasn't responded to that accusation? The proper procedure for the defendant before mass deleting would have been to request from Discord a data package. This package would be verified by Discord and include all messages and images the defendant has sent. So you understand that, 1, you don't know if I've requested that or not, and 2, you could still modify this. The Discord data package is also just a bunch of CSV and JSON files. You can just go through and delete and edit shit in that as well. So I don't know what the point is of including this, but okay. This package would be verified by Discord and include all messages and images the defendant has sent. I don't know if those Discord backups even include media. I don't think it does, but I'm not sure. I would have to go check. Due to the reckless deletion, even if defendant requested a data package now, the damage could be permanent. Alternatively, so even this, what if I just literally started deleting messages and then requested a Discord backup? So even before, this is also self-defeating. You're saying that even a data request, if you're saying I deleted shit before exporting it to an HTML file, I could have just deleted shit before exporting it to the Discord request. Like, this... Great to see the law tubers who followed your case nonstop go silent after the first public court. Yeah, it's whatever. I don't care. It's all. It is what it is. The package would be verified by, okay, due to the reckless deletion, even if the defendant requested data package, now the damage could be permanent. Alternatively, prior to the deletion, the defendant could have used Relativity or a trusted e-discovery platform to preserve evidence. I don't even know what these are, to be fair, but okay. The defendant did none of these actions, which certainly cast doubt on his intent and the veracity of his preservation. In short, a self-created export is not a substitute for original server-stored messages. In all the discovery that I've read, most of these exports are self-created, but I don't know. I haven't read a fuck ton of cases like this, so I don't know. Maybe there's different things you can do. The plaintiff cannot independently verify, 1, whether all relevant messages were captured, and 2, whether messages were deleted before export, or 3, whether timestamps, edits, deletions, or context were altered. You can't do that with I don't think with any platform on any of these online apps, but okay. In addition to Discord logs being deleted, Destiny apparently deleted his Google Drive as well. Destiny has admitted to this court that he has a Google Drive where he puts pornographic material and then shares the link with individuals. I don't know if they think that it was just like Is there like a giant folder with every single explicit video that I've ever taken just being shipped out to people? I don't know if that's what they think this means, but the individual who leaked the videos in the initial Kiwi Farms leaks, Solo Tiny Leaks, confirmed they were from Destiny's Google Drive that he shared with Rose. And the video of Pixie sent by Bonnell in November 2023 was in a Google Drive link. Exhibit 4, witness A also received videos through Google Drive, acting when he deleted it. Okay, multiple women can confirm that the Google Drive link was active within the past year. Who are the other women? Who else? Is it just the two, or the Twilight witness we brought in, and then who else? What? Okay. Multiple women can confirm that the Google Drive... Oh, they're trying to subtly imply here that it was just a link to a massive fucking repository of content. Nice. Okay, based. Good job. Multiple women can confirm that the Google Drive was active within the past year and that videos were being sent through it. Plaintiff has a right to verify said Google Drive and ensure that none of her materials were uploaded there. I also like how, oh my God, do I say this? I think I already said it earlier this stream. This whole argument is also self-defeating. If it was the case, for instance, that I sent plaintiff any videos that were recorded with a Google Drive link, because then the implication there then would have been that they were okay with that link existing the entire time, which I believe would be fatal to this entire case. But what are you going to do? Who knows? Also, I like that they sent me a cease and desist saying all of these videos need to be removed. And now they're like, wait a second, was anything deleted from any other people? Like, wouldn't technically, if there were Google Drive links of any material, wouldn't that have been requested by plaintiff to have been deleted from access for other people as part of their request for delete? Like literally the cease and desist, the demand that was initially sent. But again, this is all of this is super fucking retarded. But anyway, furthermore, back to the lawyer cuck. Okay. Furthermore, Mr. Brettler's declaration asserts that he informed the undersigned counsel of the steps defendant has taken to preserve evidence. This is incorrect. I like how she's accusing my lawyer of lying to her. The plaintiff's counsel is accusing my counsel of lying to her in conversations now. Okay. Based. Furthermore, Mr. Brettler's declaration asserts that he informed the undersigned counsel of the steps defendant has taken to preserve evidence. This is incorrect. Mr. Brettler simply insisted the defendant was preserving evidence. When pressed repeatedly as to how he was preserving evidence, the answer was only that he preserved evidence in JSON files, but no other specifics were provided. See these declarations. Declaration of mention of JSON files or any specifics. Bonnell's statement as to preservation does not mention JSON files, only HTML files, raising further suspicions. In short, based on the clear evidence submitted of defendant's spoliation, I think this is supposed to be spoliation of evidence, an order requiring him to preserve all evidence in its original format is warranted, and defendant should have no objection to the same. Okay, if you want to do something like that, fine, I guess. This is still retarded, but a preliminary injunction? No, this is not the appropriate forum for dealing with spoliation. In my uneducated, not law schooled opinion, and the opinion of the judge in this case, but... Plaintiff's fourth and fifth requests are for an order to compel defendant to direct third parties to comply with the court's order by removing any version of the video containing plaintiff's image and likenesses from any form of public media under their control, and compelling defendant to attest in a declaration that he has complied with this court's order while describing the steps he's taken to do so. Okay, wait, so why would I be directing other parties to comply with the court's order when those parties are not, one, named in this lawsuit, so I don't even know why I'm directing them, and two, they're not like directly employed by me or anything else. Like what, what? How, what is it? And also they spent the whole time saying, we only asked him to remove stuff directly under his control. That's all we asked for. Okay. What do they say? Hold on. Defendant's gaslighting distorting the facts. Plaintiff requested an order enjoining defendant by sharing publishing, whether directly or indirectly, compelling him to remove all publication, motion to completely discourage and rephrase the second request to an order of him to remove the video and all messages between him and plaintiff from the form of public media. The second request unambiguously and specifically requests that Bonnell remove the private messages from social media under his control. Oh, maybe. Oh, fuck. I'd have to go back and read. Because I'm pretty sure they wanted me to. Oh, no, they did want me to tell other people to take it down, because that's literally what they're asking for right here. So they're saying we only wanted him to remove the messages And now they're saying, but we also want him to direct third parties to comply with the court's order. Why do you think I can do that? I don't understand why you think I would have the ability to do that. I can't tell somebody else to comply with my court order. That's not how that works. To direct third parties to comply with the court's order, it's a court order enjoining my behavior. How could I tell somebody else to comply with a court order that they're not the subject of? What? I don't even know what this means. I don't even know that's possible, but okay, whatever. Based. Oh. Maybe they want the court to tell you to use your resources to try and get the stuff taken down for Jane Doe. I don't think that usually compelling somebody to do a behavior is an extraordinary step for the court. I think enjoining is usually telling somebody to stop doing something. You can issue an injunction, a stay for something, or compelling somebody to do something. That's a really big thing. I don't think as part of an injunction or enjoining something, I don't think you can order somebody to do that. But also, I've already said this before. I think I said this in my filings. They have all the exact same power to take any of this down as I do. If anything, I don't know if I argue this personally to them, personally to plaintiff before any court stuff was involved, or if I argue this in one of the filings. You really think I can message these people and have them take shit down? Like we already know who these. Like, it's not going to happen. If you really wanted any of it taken down, you should have named them as parties to this lawsuit. You should have named them as parties, and then you could actually issue them a court order. And you could say, hey, this website, because there is stuff that's still being hosted actively and is still accessible to the public, you can issue a court order to them, and you can enjoin their behavior. You can't. How are you going to compel me to do something else for a court order that doesn't apply to an unnamed party in a lawsuit? But I don't know. Whatever. Good memes. And compelling defendant to attest in a declaration that he has complied with this court's order while describing the steps he has taken to do so. Defendant's only argument in opposition, do we have a stroke, I guess? I don't know. To the requested relief is that he has already done so. However, since the video is still publicly available on numerous sites, and since the court never issued any such order with which such third parties should comply, defendant has obviously not done so. Hold on. So, I've obviously not requested anything to be taken down, but earlier in this very motion, or in this very brief, I guess, reply, they said that plaintiff has hired the undersigned counsel in an attempt to get the video removed from QB Farms and multiple other sites. They said earlier, it was in her exhibit, that they've tried and gone through a bunch of stuff to get everything removed, and only one site took anything down. So, relating to this. Whoa! Sorry. How are you going to say that it's obvious that I haven't gone through any efforts to take anything down, and then file as attached an unsworn statement by your own lawyer saying that they've taken extensive efforts to remove stuff, but nobody has replied, and then say that the fact that stuff hasn't been removed is evidence that I haven't tried to get any of it taken down? What? So did you not try either? What does that mean? Yeah, but okay. However, since the video is still publicly available on numerous sites, and since the court never issued any such order with which third parties should comply, defendant has obviously not done so. There are multiple sites, such as Kiwi Farms, that won't comply with any requests from plaintiff's counsel to remove content absent a court order. Then get a court order against the people hosting it, right? Since defendant claims that he is a victim of revenge porn, it is surprising that he would object to this request and not join in the request that the court order the removal of the video. Then order the removal of it. I don't even know if the court can issue that because those other people aren't parties. They are parties to the lawsuit. How can you enjoin somebody who's not a named party to a suit? I don't even know if you can do that. You have to file a separate lawsuit or at least name them as defendants on this one. But they don't want to do that because they're spooked, because they're cowards. That's why, by the way. But Defendant's demand for a $500,000 security bond is unwarranted. Defendant's further gaslighting and claims of victimhood. I'm gaslighting the court by claiming to be a victim, by the way. Defendant's further gaslighting and claims of victimhood extends to his demand of a $500,000 security bond. The request is beyond absurd. Not one of the injunctive relief requests made by plaintiff would restrict his ability to defend himself online, as claimed by defendant. It is not even clear from who or what defendant is purportedly defending himself online. Even more absurd. Hello, the plaintiff's public Substack disparaging me, but okay. Destiny, what is the $500,000 thing? There are 4 elements to a preliminary injunction, and I'm not going to know it. There are 4 things you have to consider. I don't remember all 4. It's, what is it? A likelihood of success on the merits, chance of irreparable harm. The 4th thing, I don't remember the 3rd thing. The 4th thing, I think, is called a balance of, on the balance of equities. Oh, it doesn't harm the public interest is, I think, 1. And then 1, I think, is like a balance of equities, basically, which has to show that you're not disproportionately burdening the plaintiff by enjoining their behavior. So let's say that you ask for a preliminary injunction and you're like, I think this guy's harming the environment. I need him to stop doing all of his business while this court case is going on. The preliminary injunction would likely fail on that, even if it meets the other 3 maybe, because, well, hold on. If you ask me to do this, I'm like engaged in, this is going to significantly harm my business. So listen, if you want to enjoin me from this behavior while we do this court case, that's fine. But if you're going to enjoin me, you should have to post a huge bond so that if I win the case, you pay me back all of the damages that were incurred while this court case happened, so that I'm not just stopping something, suffering harm, and then winning a court case and then just still being fucked for it, right? So sometimes if you are fighting a preliminary injunction, you could request that the plaintiff post a bond saying, fine, I'll stop this behavior, but you got to post a bond. And if I win the case, you're going to pay me a little bit out of that because I was further harmed by you enjoining my behavior, basically. This sounds like just throwing shit at the wall. Is this like a usual way to submit requests? Just whatever falls on your mind? I mean, I would personally say no, but that's because, like, I'll read the underlying cases that they cite, and the underlying cases that they cite are way more solid. All the lawyers' writing in the documents seem like real people, and the writing is good. The underlying citations are good. I don't know if plaintiff is writing these herself, maybe, and maybe her counsel is like letting her practice. I truly have no idea. I don't know. I really don't know. This is kind of wacky stuff that I've seen, but whatever. It's not even clear even more absurd is his claim that he will incur substantial out-of-pocket costs and fees in connections with attempted compliance. It costs no money to stop the non-consensual sharing of intimate images, remove private messages from social media under his control, preserve evidence, which he allegedly has already done, despite not providing any concrete evidence of the same. Remember, the only reason why, or one of the reasons they argued against me preserving evidence was because I showed evidence of preserving evidence earlier in this thing. They were like, look, he showed 2 instances of the same message, so he must be deleting stuff. But I can only show that because I preserved the initial messages. Or send a letter to third parties. Plaintiff's request for injunctive relief should be granted without requiring any security, or in the alternative, the bond should be nominal at best. Plaintiff has also demonstrated the requisite irreparable harm because the video and private messages are still accessible to the public, and the harm to plaintiff is ongoing and must be stopped. The whole purpose of the most important factor, I believe, is ongoing and irreparable harm. I think that's like the most important. Oh, no, wait, I'm so sorry. That's not true. That's the second one. Likelihood of success on the merits is the most important of the 4 factors. And then I think following that, it would be the irreparable harm. But it's funny because the requisite irreparable harm here is literally the video, of which I can't do anything about. So the whole, like, a large part of this preliminary injunction request relies on that wouldn't, but good one. And his opposition did not even address the remaining 2 factors of injunctive relief, the balance of equities or the public interest. And thus, these 2 factors have been conceded. Accordingly, plaintiff has met all 4 criteria for the award of injunctive relief, and the motion should be granted. Good memes. Are you in the discovery phase yet? Theoretically, we are, but defense or plaintiff has not issued any requests to me, so I don't know if they were planning on it or if we're just kind of like big chillin', but fun times. How are you feeling? Like annoyed, I guess. But you obviously address the balance of equities. Probably not, because there's not like a huge harm to me by not doing a behavior that's already illegal that I'm already doing, or not doing, like not engaging in illegal behavior, which I'm already doing by not engaging in said behavior. So, yeah. At what point does dragging out a lawsuit become malicious in the eyes of the court? I don't know. I have no idea how that works. I think you have to go pretty far to like get chastised or sanctioned or something, but we'll see. I'm curious. I hope that they rule on this sooner rather than later. One, because there's a chance that the whole thing could get tossed just right here at this preliminary injunction hearing. And then two, just it'll be interesting to see. I'm curious how the magistrate judge views all of the wacky randomness, because maybe it'll be a good forewarning, I guess, on how the primary judge will view things. But how are you absolved from foreseeability? Well, I mean, I think it would be strange to argue that if you send explicit material of yourself to another person, that it's foreseeable that that material would leak, because then that would mean that by recording something and having it with somebody else, that your own behavior would make it foreseeable that something would leak. That would be kind of self-defeating. Does that make sense? That wouldn't really... Like, if I were to record a video of myself, okay, like teddy bear, and then I send it to somebody, and if they were to send that video to somebody else, and then I were to sue the first person, if the second person, say, publishes a video online, and then I were to ask, and I were to say to the first person, well, I'm suing them and it's foreseeable, they should be accountable for all of the damage of the public posting that video. And my argument is, well, if you're going to send an explicit video like that, obviously it's going to be published. Well, the foreseeability argument is self-defeating because I sent the video in the first place. So then should I have foreseen the damages that it would have caused? Then, right, it's like a self-defeating argument. Is foreseeability even an element here? The federal court statute is basically a strict liability offense. Not when... I don't even know if strict liability is part of this or would count here. But the foreseeability and everything, and I think proximate harm are concepts that you would talk about when it comes to assessing damage to a person or who's liable for damages to a person or whatever. Are you worried at all about this, since this is heavily integrated with technology that judges may not understand things well or might slow down the trial? I mean, this is already going slow. It's already going to take months more, however the long. They're going to draw this out. Reading the judge talking about it at the TRO hearing seemed like they understood things pretty well, so I was pretty happy with that. What exactly is their aim with the PI? Just to stop you from talking about it public? I think they just want to get any win, like any motions that they can file that they can get wins on. Maybe if they get like a PI, you know how like Trump will say shit like, we had a big win in court, guys. And it's like, what was the big win in court? You know, we defeated a TRO or we got like a TRO. It's like, okay, well, you didn't really win your case. But people will just say that like, oh, we won because we got this. So I don't know, maybe they're just looking... Oh, and maybe actually it could be like a fundraiser thing too. Like say they were to get a preliminary injunction, they could argue that they have like a type of restraining order against me, but I finally got a restraining order against my abuser, but I still need more help. Like please donate to win this so that I can continue being victorious or whatever. Maybe that'd be my guess, I guess. That's my guess. I truly have no idea. Like I said, the whole thing is like kind of wacky and ridiculous, but. So you're saying that by sending explicit media, it implies that you cannot have foreseen public distribution. That would be, I would imagine that would be the argument. Otherwise, every single person that would send stuff would automatically foresee it as being published online. Like that wouldn't even... Were your lawyers mad about you posting this? No, I generally check everything with them first, generally. But do you think they're going to prolong court proceedings with random filings, continue to restrict you from being able to operate your business normally? Yeah, that's probably the goal. Is to... meme as hard as possible. From what it's been explained to me, it's exceptionally rare that you're awarded other people's legal fees in cases. Basically, I was just told like everybody basically pays their own court costs. So I don't know if I would get those back or not. I seriously doubt it. Well, maybe if they continue, maybe they continue acting this way. But that would be very bad for the other side if that was the case. But I don't know. Even if you win, do you have to cover your own lawyer expenses regardless of anything? Probably, yeah. That'd be my guess. Memeing with malicious intent. True. Did you go over the Abby MC affidavit? I feel like that's going to be a big thing. They don't provide any evidence, so I can't. There's nothing for me to go over. It's just it's an affidavit of a person. I don't even. I'm not a lawyer. I don't know if there's any lawyers. I don't know if you're allowed to do that, to just have like random people join a case and just start filing like unsworn statements that were never mentioned in the original complaint. Because remember, if you remember, plaintiff in the original complaint stated that a supporter approached her and said that her sister had received some video at the end of last year or something. But now plaintiff is asserting that a different person has come forward and has said, and it's, I don't know if you can just keep like throwing on random, like random people, but I don't know, who knows, I guess, especially because I didn't have a chance to respond to this. Yeah, especially because this affidavit wasn't even attached to the request for preliminary injunction. It was the response to our response to it, and I don't think we don't get to respond to this one. I guess we could file a separate motion, but it's just like, what the fuck? I don't know. But it'll all come down to how the magistrate judge views it, I guess. Yeah. Is an affidavit like a deposition? Actually, I keep saying affidavit and unsworn testimony. I don't know what unsworn versus sworn testimony is. I don't know the differences between that. I'm pretty sure it's all done under penalty of perjury. Deposition, I think, is usually where you sit down and you are asked questions or you're cross-examined by the other side, I think, prior to going to trial. I think plaintiff feels about how this is going. I don't fucking know. Don't know. Don't talk to him. Don't talk to that friend group. No clue. Are the judges actually going to go through and see if all the underlying court cases match the arguments in the docs? I just don't know how the judges would read any of this. Keep in mind that this law is still like relatively new. Like it came into effect 3 years ago. So there's not very much case law that I've been able to find on this. However, the issue is my case is going to be pretty novel because at least all of the cases that I've seen that are invoking this statute, all of them have to do with like incredibly unhinged defendants. It's usually men that are like spamming intimate videos or pictures to like friends and family members of plaintiff, or men that are like abusive or like then the one it was like threatening to kill himself and then making secret accounts to like spam explicit videos and images. So those were like all of the cases that I read about is usually that. I haven't seen any cases yet, I don't think. Also, if anybody wants to email me some, I'd love to read them. I'd just be curious. I haven't seen any cases where it's just like somebody transmitted a video to another person without authorization and then they were sued for. I haven't seen any of those. But I mean, maybe it's there might be some. I just haven't found them. But is there an active restraining order for you and plaintiff? No. I love you guys. It's been fun. Stay safe. Ripperino, cappuccino, poppuccino, hoppuccino, moppuccino, cappuccino, cappuccino, appuccino, al pacino. My Deuterinos, Rippuccino. Stay safe. Be careful. Oh, wait. Connections. Do we have a date for the hearing? I don't think, because it's a magistrate judge, I don't think they have to schedule a hearing on the PI. I'm not sure, so. Is there a reason why you've been so open lately about the case when it's probably better to give 0% chance for the plaintiffs to use these statements? Well, remember, this is a civil case, so the only thing that I have to fear, the only thing that can hurt me, or the only punishment that can be levied against me are financial ones. So if there is a reputational gain or financial stake that I have in curing some amount of my reputation, then it's worth it for me to talk about it publicly, right? There's no, if I'm quiet for 2 years and then I beat the case at the end, and I maybe slightly help my case by never talking about it, but for 2 years I'm viewed as like a rapist. It doesn't help me. It's like, yeah, the only injuries that are available here for me are financial ones, right? So it doesn't make sense for me to, and these are all public filings. They're publicly available anyway. Also, if fake lawyers or penny lawyers are gonna fucking review these docs and give the most retarded legal analysis ever, then fuck it, I'll read my own shit. If you lose, doesn't it hurt your reputation more? I don't know, actually. I truly don't know the answer to that. I don't know if losing or winning this case will do anything for my reputation. If I win, people will either say it was on a technicality or it's because I've seen some people say, like, oh, it's because he has better lawyers. If I lose, people already think the same thing anyway. I don't actually know if the outcome is that important in terms of reputation. So, you know,